Welcome back to another episode of What to Expect When You're Arrested. I'm your host, Sean Henricksen, and I'm from the Sean Henricksen Law Firm, where we help good people like you avoid the devastating consequences of criminal charges. Today, we're going to be talking about trials. Before we get to that, we do have a free download for you. It is 5 things you should be doing right now if you've been arrested. If you click down in the show notes, then there's a link there, and we will send that right out to you. Just a quick recap. Remember, when you're charged with a crime, there are 3 ways that your case could end. It could get dismissed, you could decide to accept a plea agreement on that, or your case could go to trial. So what is a trial? A trial is where the state, who's represented by the district attorney's office, is going to try and prove beyond a reasonable doubt that you committed whatever crime you're being charged with. There in the courtroom during the trial is going to be the judge, there'll be the prosecutor, there'll be you and your defense attorney, and there's going to be the jury who's made up of either 6 or 12 different people, depending on whether it's a misdemeanor or a felony. Now, one question that I get a lot, and I hear a lot of people don't want to have a trial, but there's a couple of things you need to think about when you're making a decision about whether or not you want to take your case to trial. During your case, you're going to get offers from the district attorney's office. And when making a decision about whether to take an offer or whether to take a case to trial, you're going to want to talk to your attorney, because what you're trying to choose between is, if this case did go to trial, what does that trial look like? What is the outcome likely to be? And if you are found guilty, then what is likely going to be the punishment? And that's what you're comparing the offer to. So if you think that even if you took the case to trial, you're still going to have a better outcome than if you were to take the plea, then you probably don't want to take the plea. Or if you think you've got a really good chance of winning at trial, then you probably don't want to take that plea either. One important thing to remember is that anything can happen in trial. And what I mean by that is that there's no guarantee that either side is going to win. Even if it looks like the state has a strong case, there could always be problems. They may have a witness that they can't get to come in. They may be expecting a piece of evidence to be admitted to the jury, and that piece of evidence may not come in for whatever reason. Or maybe there's a witness that comes in and testifies differently than how one of the parties expects it to. And so even if the state has a strong case, or if the defense has a strong case, there's no guarantee what the outcome is going to be if you take the case to trial. Now, the trial could be either a bench trial, which is a trial where the judge is deciding whether you're guilty or not guilty, or like most trials, it could be a jury trial where it's a jury who's deciding whether you're guilty or not guilty. And that's one of the decisions that you'll have to make early on. And if you want it to be a bench trial where the judge is deciding if you're guilty or not guilty, the prosecutor actually has to agree to that also, because the state has a right to a jury trial as well. Another thing that you're going to do before trial is what's called election of punishment. And this is kind of unique to Texas. Most states don't let you choose this, but in Texas, if you are found guilty in a jury trial, you can choose to have either the judge or the jury decide what the sentence is going to be. And so if you go through a jury trial, if you're found guilty, you can still have the judge be the one who decides what the sentence is going to be. And really, this is more common on misdemeanor cases. There are some felony cases where you're going to go to the judge for punishment, but almost all the time on a misdemeanor, you're going to go to a judge for punishment, because the judge is most likely going to give you probation in a misdemeanor case. The first real part of a trial is what's called jury selection. And that's where a group of citizens comes in, and it's going to be the prosecutor and the defense attorney both have the opportunity to question and start a discussion and everything with the jury panel to basically try and decide if there are any people on that panel who are not going to be fair in this case. And if there is somebody who can't be fair on the case, then you can take them out of the jury pool so they don't end up on the jury. And you can do that to as many people as you can who aren't going to be fair or aren't going to be a good fit on that jury. Each side also can challenge a certain number of people just because they don't like them for whatever reason, so long as that reason isn't race-based, gender-based, or religion-based. Pretty much any other reason you can take them off. So if there's somebody who during jury selection sounds like they may be leaning more towards the state side or may, be really pro law enforcement, we may not want them on the jury, and we can take a certain amount of those people off of the jury as well. And basically, the jury is going to end up being the first 6 or 12 people who don't get taken off of the jury. The first real part of the trial is going to be opening statements where each side gives their version of the case. And so the state is going to go and tell why they think that the defendant is guilty. The defense is going to go and tell the story maybe from the defendant's perspective and explain what the jury can expect to see and why they are not guilty. After opening statements, the state is going to be able to put on their side of the case. And what that means is that they're going to be able to call whatever witnesses they want to call and try and get into evidence, whatever evidence they expect to try and get in. And when they do call witnesses, they're going to be able to question those witnesses. And for each witness, the defense is going to have an opportunity to cross-examine those witnesses. After the state is done calling all of their witnesses, then it's the defense side's turn. So we will go ahead and put on any witnesses that we have. If you are choosing to testify in a trial against yourself, then this will be your opportunity to go on and you'll be a witness in your own case. It's important to remember that if you do choose to testify in your case, that the state is going to have the opportunity to cross-examine you as well, because they will be able to cross-examine any witnesses just like the defense had the opportunity to cross-examine any of their witnesses. After the defense is done putting on their side of the case, then each side is going to give their closing statements. The state is going to argue that they met their burden, that they proved beyond a reasonable doubt that you did whatever crime you're being convicted of. The defense is going to argue that there is reasonable doubt, and the state did not meet their burden and was not able to prove beyond a reasonable doubt that you did commit that crime. After closing statements, and the jury is going to have the opportunity to go back to the jury room and deliberate. This is going to be their first opportunity to talk to each other about what they think happened. And they're going to have to come up with a unanimous decision, whether it's guilty or not guilty on the case. If they can't come up with a unanimous decision, either for guilt or not guilty, then there's going to be a mistrial, which means that everything can start over again and there could be another trial after this. If the jury comes back with a unanimous verdict that you're not guilty, then at that point, your case is done. You're free to go. You've got no more court dates. You're not on bond anymore. You don't have to check in with pretrial services or anything like that. And you're eligible for an expunction, which means that you'll be able to get your criminal record cleaned up so that this doesn't follow you around for the rest of your life. On the other hand, if the jury comes back with a guilty verdict, then that's when it goes back to whether you chose to have the judge or the jury punish you on this case. And if you chose the jury, then we're going to go into a second phase of the trial, which is called sentencing. And again, each side is going to be able to call witnesses to basically try and convince the jury what the right punishment is in this case. After sentencing, there's basically going to be two options that the judge or the jury can come up with. Either they can give you probation or they can give you jail or prison time. If they give you probation, then you'll probably be told to report to probation on whatever date. If you're given jail or prison time, then you'll be taken into custody to serve out your sentence. If you have any questions about what trials are, or if you are being charged with a crime here in San Antonio, feel free to click down on the link in the show notes to set up a free consultation where I'd be happy to talk with you. Or you can give us a call at 210-775-3057. Thank you and have a great day.